Okay, here we are. 2026, Scott. Another episode of Prescription for Better Access.
Yeah, great to be back with you again, Mark. Always enjoy it.
Well, February, what a month for our industry with some big actions against PBMs, starting with the FTC's decision to or settlement with Express Scripts and Cigna, and then the sweeping PBM reforms that were included in the Consolidated Appropriations Act of 2026.
Yeah, fantastic. We've got a wonderful guest here with us today to help us make sense of it.
We do. Bill Sorrell, we're thrilled to have you. He's a retired attorney from Sidley Austin. He's also a professor at University of Maryland Law School, which is important to my family. My brother-in-law, my my in-laws all went there. And also 8 patient advocacy organizations that he's a volunteer attorney for, where, again, my roots are in the nonprofit world. So just thrilled that he continues to do all of that. So,
Yeah.
Bill, welcome to the show.
Well, thank you so much. I'm delighted to be here.
And I'm going to kick off, and then Scott and I will sort of mix up the questions as we go through. And don't be surprised if there's a follow-up or two based on the conversation. But first, why don't you sort of help us understand, take us back to the government's decision to investigate and then sue the big three, and help our listeners understand how and why this happened.
Sure. Well, definitely a topic that I've been following for a long time. It's of tremendous interest, obviously, to the patient advocacy groups that I work with. I'm speaking today, obviously, only in my individual capacity, not for anyone else, but definitely has been an interest for those that I'm working with. And it's a significant interest just for me personally and my family. I'm a rare disease patient. So when I look out to hopefully the day when we finally have for my form of muscular dystrophy a treatment for the first time, navigating PBMs and the likely impact of PBMs on a cell gene or other therapy is personally important to me. The government, under the leadership of Lina Khan and the Biden administration, decided that PBMs were a significant issue that needed to be addressed, and that not insignificantly it should be addressed through the Federal Trade Commission. So the FTC at that time opened special order procedures in order to collect information from a number of PBMs beyond the big three, and produced 2 interim reports. And in between those 2 interim reports, filed administrative complaints against the big three, really centered on insulin pricing issues. And now we have the first settlement of one of those component administrative complaints, as you indicated, ESI, Ascent, the Cigna-related entities.
Bill, our listeners are keenly interested in this kind of stuff, but we're not, all expert in the details and in the kinds of things that you understand well. And so explain to us a little bit here what we might expect could actually change with this recent enforcement action and settlement against Express Scripts. What's likely to not change, what stays the same? Were there any fines involved? And then where are we with Caremark and Optum?
Yeah, no fines. This is a settlement agreement that imposes certain obligations on those entities going forward, beginning January 1, 2027, or if they happen to implement this earlier, at that earlier date. So it's not currently in effect. It will be in effect no later than January 1, 2027. Whether this is going to be a huge impact or not is sort of in the eye of the beholder. There are people who see this as a watershed event that will fundamentally change the way that pharmacy benefit managers and their affiliates operate in the marketplace. There are others that are very skeptical and think that it will have not that great an impact. And then there are people like me in between that do think it's a pretty significant event. We had an administrative complaint that focused specifically on insulin related issues, fairly
Mhm.
narrow. This settlement is actually much broader, much broader than just the insulin products. It covers a number of the issues that are of significant concern to the critics of PBMs, but it's also true that there are some areas that are not addressed, and the relative importance of what is addressed versus what is not addressed probably will take some time to shake out to figure out which of those two ultimately is more influential in the impact.
Mhm.
So I think what I can do is start off by summarizing
Yeah.
what the FTC settlement agreement calls for, and then we can talk about maybe some of the limitations
Great.
with the document on the other end. All right.
Great.
So consulting my notes, the very first thing that the FTC settlement does is require that the PBMs delink, this is the terminology, delink their compensation calculations from the list price of drugs. And
Mm.
that is an extremely important component of the FTC settlement. Next, it says that the PBMs cannot discriminate against lower list price versions of drugs in favor of the higher list price versions of those drugs. Next, it says that patients must receive the benefit of the rebated price at the counter. So that's potentially huge from a patient perspective. As I look at the FTC settlement, that could be very, very impactful indeed.
Yeah.
Because of course, the way that the system works now, unfortunately, is that when patients pay out of pocket deductibles, coinsurance, they're doing it based on this high list price, right?
Right.
So 30% of an imaginary high price is a really big number. 30% of a true net price number could be substantially reduced. So that's potentially some very good news. The next element of the FTC settlement, which is works in tandem with the one that we just talked about, is that whatever that out-of-pocket amount ends up being, it is not to be higher than the net cost of the drug.
Mm.
We saw, obviously, many, many situations where people were told, well, you're going to pay 50%
Right.
in coinsurance. It turned out that that was more than 100% of the net
Right.
cost, right? So that
They
could
were
be,
making money.
they were making money. Sick
Mm.
people getting insurance, hoping to spread the risk, were not spreading the risk. They were actually paying for the healthcare costs in many cases of healthier people, which is
Yeah.
just the world upside down. The next one is a prohibition on rebate guarantees. And this is, of course, the marketing mechanism that some criticize, where PBMs say, well, you should sign on to us again because we're going to guarantee you X amount in rebate guarantees without explaining what the trade offs are associated with those rebate guarantees. So that might sound like a great deal, but not be a great deal. So we have a prohibition on those. We have a prohibition on spread pricing, the notion that the PBM can pay a pharmacy one amount and
Mm.
then charge the plan a higher amount for that same drug dispense. We have a requirement for disclosure of drug product costs, including claims data and consultant compensation. We have a requirement that retail pharmacies be reimbursed based on their actual acquisition cost. They can't be paid under this provision less than what they're actually paying to get the drug. But there's a little bit of a kicker here. In order for the pharmacy to get that protection, the pharmacy actually has to provide data on what its actual acquisition cost is. This is one of those places where I'm uncertain what that means from an implementation perspective. Do pharmacies sort of say, well, I'm not sure I really want to share that information? So that's an interesting one. Next, I've got two more here. One is that retail community pharmacies must be included in networks to the extent that they're willing to accept standard network terms. And
Mhm.
then finally, the one that was near and dear, no doubt, to the president's heart, that Ascent would have to reshore to the United States and could not operate as a foreign corporation.
That's an extensive list, Bill.
Wow.
And when you think and that's the wow, absolutely. When
Yeah.
when this administrative complaint was filed, it was very narrowly focused on insulin, and people thought, "Well, that's nice, but, how impactful can that really be?"
Right.
So for those who are in the wow camp, that is the wow. All right, so now what's the not so wow? Well, the not so wow, the concerns include that this affects a group of plans and a group of offerings from the Cigna group. So it does not cover all plans and does not apply in all circumstances by a long stretch. Second, most of these protections apply to standard offers made by ESI. And what is a standard offer? It's the offer that they make if the customer, if the plan sponsor, the plan fiduciary doesn't say, hey, I want a customized offer.
Mhm.
If they request a customized offer, then a lot of these protections are off the board simply by virtue of that procedural twist. And of course, critics say, well, we think that these PBMs will be very effective at securing those quote unquote requests
Mm.
in order to avoid the application of many of these safeguards. Others are critical. They like the fact that compensation is going to be delinked from list price, but they note that with respect to these compensation items, there is no fair market value test for fees. So some people say, look, the real issue ultimately is
Mm.
in their view that these fees exceed fair market value. This agreement doesn't create a fair market value test. Now that may exist in law elsewhere, but then again, it may not exist in law elsewhere. So that's a source of concern for folks. And so again, you have three camps: a wow camp, this is fantastic; a very cynical camp at the other end of the spectrum; and then the half a loaf people like me in the middle who wonder if the PBMs were already moving towards a less rebate oriented relationship with their customers, and that they may have enough wiggle room here in terms of alternative fee structures to
Mhm.
unfortunately replicate at least a good deal of their ability to leverage off of their customers.
Gosh, there's a lot there, right?
Mm.
And that's an incredible list. Let's sort of before we think about how it impacts the community and the industry and the different groups, which I want to get into, let's just talk also about the PBM reform because that occurred last week or
Mhm.
last month as well in February. And that was the PBM reform that was in the Consolidated Appropriations Act. Uh, what if you had a chance to sort of list what's in that one for
Yes. Well, fortunately, it's a little bit shorter of a list.
okay.
This one also has a D-link compensation from list price provision. It has semi-annual reporting, which includes gross to net drug spending, spread pricing, formulary rationale, and benefit design. And then it also creates a space for CMS to have the authority both to define and enforce what are reasonable and relevant contract terms with respect to PBM contracting with pharmacies. So The appropriation language does some things directly, and then it empowers CMS potentially to do some additional things. So what's the limitation? That sounds great. What's the limitation here? Well, the limitation is that this is all Part D plan specific. So that's a pretty big limitation.
Yeah.
So when you think about the two of them, I mean, one is law, right?
Yes.
And then the other's an enforcement action. Help us understand, as a non-lawyer, help us understand the difference.
The law applies within the entire sphere that Congress has spoken to. So, with respect to all arrangements in Part D that are subject to this appropriations language, this is now a mandate. It requires no further action by the government to impose these obligations in these circumstances. For in connection with the FTC settlement, it applies right now only to the Cigna related entities and affiliates. And it only applies beginning January 1, 2027. And the real test of it, of course, is the extent to which it is implemented consistent with the document.
Right.
Now, the document itself, to some extent, speaks to that. It creates a monitor that operates sort of within the internal structure of these various entities in order to be an advocate for and, in some sense, a judge of the implementation of these provisions. But sometimes companies don't live up to their FTC or other settlement obligations. So, to some extent, how this is implemented, how strictly it is implemented, could be a function of what the federal government's appetite is for enforcement on the back end of this agreement.
And what might we normally expect for the remaining actions, I guess, with Caremark and Optum, Bill?
Kathy Kelly from the Pink Sheet did get a quote from the folks at CVS Caremark indicating, I'll read that from her article, which I commend to the audience, that CVS and Caremark, spokesperson for CVS Caremark said that the company is, quote, engaging in good faith negotiations with the FTC staff regarding a potential resolution, unquote, which is corporate affairs speak for, yes, we have seen the settlement. We understand that it is highly unlikely that FTC is going to agree to something less extensive for us than they did with respect to the Cigna entities, but we're sure going to give a try to do that in negotiations. And we are seeing the writing on the wall, but still hoping to get a better deal.
Yeah. Do you think this is the full basket for the government, or are there any things remaining that you think they may still be interested in down the road?
Well, sometimes there is a discount given to the first entity that settles. So sometimes it gets the best deal, and there is slightly less good deal that follows for the person that settles twice and the person that settles the third time. I don't know whether that will be the case here or not. But I think that the FTC, from its perspective, having committed to this basket of settlement terms, probably is going to be pretty resistant, certainly, to cutting back on this list.
Now, I know Cigna is an Express Scripts. They're big. They're really a big TPA, right? That's the majority of their customers are the TPA, not the fully insured. Is there any difference in the enforcement, and if you use them as a fully insured versus as a TPA? Any differences there?
I think there could be. There are references to Cigna plans. It was one of the limitations that I talked about. So in some cases, some of these provisions apply to Cigna plans. The distinction between a self-insured plan and a fully insured plan is definitely at the heart of the third leg of this stool, which is the Department of Labor proposal that came out in the midst of these other two developments.
Mm.
So that proposal is specifically for self-insured plans. Fully insured plans are excluded from that DOL proposal.
I'm sorry. That one I wasn't even aware of when we started this call. So help me get up to speed real quick. What is the Department of Labor proposal that I guess I was frozen under by all this snow, but help me understand.
There's only so many breaking news events at any one time that any of
Yeah.
us can tolerate, I suppose. So this one is not quite as extensive in terms of the number of items as the FTC settlement, but more extensive than the shortest list with respect to the
Mhm.
appropriations language. So this one is a proposal. So it's just a proposed rule. It's not a final rule. It's just the beginning of the regulatory rulemaking process. And it first says that PBMs must disclose to plan fiduciaries the compensation that they have received or are reasonably expected to receive, whether it is direct or indirect compensation, and that extends to its, quote, affiliates, agents, and subcontractors. So the first one is a disclosure provision focused on compensation. The second one says that there is a disclosure obligation to plan fiduciaries that requires disclosure about compensation to, quote, affiliated providers of brokerage and consulting services, end quote. So this is
Mm.
focusing on the relationship
Right.
between the PBM entities, obviously, and the brokers. The third is that there must be disclosure of net costs of drugs. Fourth, there is an audit right that is created here for the plan fiduciaries. And fifth, there are limits on how the PBMs can use confidentiality agreements to limit the plan fiduciaries' use of the information that they secure either through disclosure or through audit, which obviously has been a huge issue in the past, where
Right.
in the information that they received, there was some real doubts about what, if any, circumstances they could actually use that information. So what are the limitations here? Well, we covered probably the most important one, which is that this only applies to self-insured plans. There are, unfortunately, other limitations. The compensation that is subject to disclosure here is pharmacy benefit management services related, meaning the management or administration of prescription drug benefits. So what does that mean? Well, it turns out that probably DOL itself doesn't really know right now what it means. It asks the question in this proposal whether it has written in its proposal a proposal that is broad enough to get to the GPO fees or not.
Mm.
It is itself is unclear whether it has achieved that or not. But it is clear that this doesn't apply to any non-drug compensation that PBMs have. So to the extent they own physician clinics or ambulatory surgery centers, to the extent that they're doing claims processing for non-drug claims, all of that would appear to be beyond these rules. Also unclear when they do a private label drug. Is that
Mm.
a
Yeah.
PBM service, or are they now a manufacturer? So that's a different thing altogether. So there are a fair number of questions, which is not unusual, obviously, in a proposal. That's part of the process of getting comments and responding to them, and then obviously making changes in the final rule. But those are among the potential limitations of this policy.
Strikes me there's a lot here about the relationships between the entities and, list prices and nest prices and rebates and all that kind of stuff, but not much about some of the other things that are troublesome for practices and patients. Formulary exclusions, growth in formulary exclusions, prior authorization difficulties, step edits, the level of patient cost sharing, that kind of stuff. Am I hearing that right, Bill? Is that
I
correct?
think I think that's directionally correct. I do think the FTC settlement, when we talk about, out-of-pocket costs, that one,
Yeah.
with 2 different provisions speaks pretty directly to that problem, and so that's, pretty, potentially, positive.
So it may still be a high percentage, let's say, of the drug cost, but at least it'll be the net cost, not the list.
Yeah. So then, this is one of those implementation questions.
Yeah.
On a drug where, the PBM is getting a 75% rebate and says to the patient, well, we want you to pay 50% of
Yeah.
the cost, right? That may be offensive to the patient, but it's not as offensive as it should be because they don't really understand that they're paying
Right.
50% of a made up number.
Right.
Now, if it's based on the net cost, does that 50% become 75%, 85%, or do the PBMs and the plan fiduciaries go, yeah, nobody's going to go for that. If we tell them what the actual percentage is, geez, that's going to really create some problems for us. Do we, as a PBM, try to figure out a different way to get that revenue stream replaced? So
Right.
we'll see. We'll see how that actually gets implemented.
Yeah. Interesting.
All right. So the way I look at this is that you have the FTC actions, you have obviously the PBM reform, which focuses on Part D, and then you have the Department of Labor, which again, as you said, is for the self-insured plans only. Um, it seems like February is a big month for literally like chipping away at some of these fundamental things
Mhm.
around drug pricing, access, affordability, some of the big problems, right? Um, if I know you, I don't want you to have a crystal ball, but over the next couple of years, how do you see this potentially impacting? Um, let's start with like the plan sponsors, right? The employers, uh, whether it's the government and Medicare, Medicare Advantage plans. Help us understand some perspective on how you think this might sort of ripple down over the next couple of years.
Okay. Well, one major caveat here at the beginning is that there's at least some possibility that some other piece of legislation could occur before the end of the year. I think there are different schools of thought about how likely that is or isn't, but we have the Crapo-Whiten bill out there that is certainly broader than what was implemented through the appropriations language. So, in part, your question is a bit of a moving target because there yet could be another component that needs to be considered. I think my best answer to that fantastic question is, I don't really know, and I'm not sure anybody else really knows what the impacts of all these are. I would say that I was struck in particular when I look at the DOL proposal with the way that the government framed that. So, in part, what they do at the very beginning of the document is say, look, we want to tell you why we're mandating these disclosures. We're mandating these disclosures because, in combination, the ERISA law through sections 406 and 408 require planned fiduciaries when they have a contract with a party in interest to determine that that contract is necessary and that the compensation under the contract is reasonable.
Mm.
And so that's a shot across the bow, not at the PBMs, really. That's a shot across the bow at the planned fiduciaries. And we've
Mm.
obviously seen where there's been an uptick in complaint filings that
Yeah.
pick at that question. And, this information is indeed potentially quite valuable to the planned fiduciaries. It also puts the planned fiduciaries in a position where they've got to do something with it.
Yeah. Very interesting.
Do you want to turn towards some of your favorite topics, Scott?
What are you thinking here, Mark? Some of the other things that are going on?
The manufacturer's perspective?
Well, yeah, I guess, of course. Yeah, if you're thinking about this from a manufacturer perspective, would you assume now that your net prices will be discoverable, I guess? And then, how might that influence how they think about these kinds of relationships and the way they, reach decisions about net prices and those things, Bill?
Yeah, well, more transparency is more transparency.
Yeah,
That's the nature of the exercise. It probably varies by manufacturer. I think obviously some manufacturers, and I'm not speaking for manufacturers. I used to
sure.
represent them, but I have no inside information about
Sure.
their current plans by any stretch. I think my impression, just as an outside observer, is that some manufacturers are at this point pretty committed to trying to remove middlemen of all kinds as much as
Mhm.
possible and getting as close as they can for as large a portion of their services as possible to a direct relationship with the patient. For those folks, they probably look at this and say, this is consistent with where we want to go, and we're going to have to be transparent about our own prices in order to
Mhm.
effectuate our own strategy. For manufacturers that, haven't decided that is in fact the wave of the future and how they want to structure predominantly their launch and ongoing marketing activities, I think that there will be some ambivalence about this. Wow, okay, a lot of people are going to know what our net
Yeah.
price is. That's interesting. Again, it's a moving target though, right? That assumes that what, has continued to be, even with some significant evolution, a pretty rebate impacted pricing regime continues to be a pretty heavily impacted rebate regime.
Mhm.
And that's not at all clear. I mean, it's possible that one of the reasons why ESI and its affiliates were willing to settle and why they, in particular, wanted the focus on January 1, 2027, is that they are already anticipating making some very significant switches off of a
Yeah.
rebate-oriented system to an even more rebate-oriented system, or to private labeling approaches, or to any number of other strategies that might be open to them.
I can imagine from the manufacturer's perspective, this is new territory for them as well, obviously. And so having, you know, net price based formulary decisions, um, there's obviously some great things about that from a manufacturer perspective, but then there are some unknowns. And then having patients, um, cost shares tied to those net prices, they may turn out to be pretty cost sensitive shoppers, and so it could actually, at least in certain circumstances, increase competitive pressure.
Yeah, well, that's right. I mean, if someone is going to be told, well, you're going to spend 90% of this drug, that's on a net price
Yeah,
basis, what we're now looking for from you.
yeah,
That is probably more likely to prompt at least some patients to say, all right, is there an alternative to this 90% one?
yeah,
Is there
exactly.
a 50% one, or maybe even, I don't know, a 20% one that I might be able to use? So, yeah, it will be interesting to see how this plays out.
Any thoughts on the 340B or IRA or the MFN discussions? Any sort of ripple into that area?
Yeah, well, obviously the appropriations language is specific to Part D, so there is obviously an overlap to MFN in that particular context. That's the hardest of the hard questions, right? Because now you're asking, which is a great question, how these various things all happening at once interact with
Yeah,
each other. I have to confess that I'm struggling to figure out what the reaction will be to each individual piece, let
yeah,
alone the interactions among all of these. I would say that I am skeptical for a variety of different reasons, that CMS's sort of postulate out there that it had under the Biden administration that the first 10 drugs would save $6 billion. I remain as skeptical today as I was the day that CMS announced that.
Mhm.
I would say that some of these provisions could double down on my cynicism with respect to what sort of savings, at least in year one,
Mhm.
generated under MFN, because I think there's at least an argument that this creates some incentive on the part of now not just 340B entities, but maybe the plans themselves to rethink whether they are pushing patients to or away from MFN drugs.
Mhm.
So I do think that there is some possibility for interaction there. I'm not so bold as to say I know how the interaction will work, but I know that there are market access people all over
Yeah.
the country who are trying to figure that out, and that by the same token, there are PBM execs and Part D plan execs who are engaged in the same exercise.
Yeah. Very interesting.
Before we wrap up with our final question, I just want to ask, and because we face this a lot with a lot of our episodes. I'm sure you've listened to all of them, Bill.
Twice.
Yeah,
Absolutely.
Yes.
twice. Yes. But again, something that Carl's been pushing heavily, at his organization, and that's around copay accumulators, copay maximizers, the offensive alternative funding programs, which are just outrageous that you're covered by a drug, but the minute you're diagnosed with it, they take it off formulary.
Yeah.
Um, so help us understand, like, will the any of these changes sort of impact some of those those kinds of programs?
Yeah. There's a lot of energy behind those three waves, unfortunately. I do think that there is some chance that some of the energy behind those waves can be affected by some components of these various proposals that we've talked about. Um, it will, for instance, in disclosures of compensation, be the case that various parties will have greater transparency as to the extent
Mhm.
to which PBMs are profiting from their connection to these various programs, and that could be eye-opening to at least some
Yeah.
actors in the marketplace. I don't think, though, that we go from three very strong waves moving very fast to the shore, picking up momentum to a placid sea based
Mhm.
upon any of these developments or even all three of these developments. I do see some positives out there on behalf of a number of patient groups. We have filed an amicus in the Gilead uh, litigation, now on appeal in the Fourth Circuit, which secured successfully an injunction against alternative funding programs which involve the foreign importation of misbranded
Mm.
drug.
Yeah.
And I'm hopeful that that appeal will sustain the injunction by the district court. If so, that's a real pathway, at least in connection with alternative funding programs that involve foreign product that manufacturer after manufacturer could replicate. So that's potentially a good piece of news, though obviously with a fairly narrow application to one of the three waves.
Mhm.
In addition, with HIV and Hepatitis Policy Institute, we filed an amicus brief in the Iowa litigation, in which the Iowa insurers have challenged uh, two provisions in the state's reform legislation that required out-of-pocket costs to be counted in the calculation of those costs. So maximizer and accumulator costs, and that could be really helpful. The challenge that the insurers have brought is that they say that is preempted by ERISA, that the state doesn't have the authority to do that. We looked at that question and concluded that we thought that was absolutely wrong. And that is the premise, of course, of our amicus brief. So we'll see how that appeal is resolved. If that case is successful, it provides an opportunity to go back to all of those states who have banned accumulators and maximizers in some circumstances, but often pretty much always not in an ERISA context, and say, see, here, there's an opinion that says you can extend your pre-existing policy to those ERISA plans, and that's what you should do.
Great stuff, Bill. Thank you so much for joining us. We always end a episode with our guests, giving them the magic wand. If there was something that you could take action on yourself and ensure that it was going to happen to help improve patient access to medicines, what would that be?
Well, to some extent, it is some meaningful extent. It's reflected in the ESI settlement. I think that, if there's one single thing that we need to focus on, it's that patient out-of-pocket costs should be based on net cost. The sham here of out-of-pocket costs that are based on costs that no one else is actually paying is the root, I would say, of all the evil here. So very pleased to see that in the ESI settlement.
Yeah.
I wish that were to extend, for instance, to 340B. Same problem.
Yeah.
And we're talking, obviously, about patients who are absolutely in need by definition of the fact that they are 340B patients. And yet we have no obligation in existing statute that the 340B patient actually be the beneficiary of the 340B price in any sense. It's up to the goodwill of a particular 340B covered entity to do that. The research I've done with IQVIA, unfortunately, in a contract pharmacy context, shows that that almost never happens, that for 95% of all 340B patients at contract pharmacies, there is no evidence in the claims data that they've received any benefit of the 340B price in connection with that dispense. It's terrible, indefensible.
Those are two good ones. Yeah,
They are.
Yeah.
And Bill, thank you so much for joining us and enlightening us. Maybe not Scott, but certainly enlightening me. And so really, really appreciate your time and your thoughts. And Scott, I don't know about you, but I think we need to have a lawyer maybe here a little bit more often.
This has got to be a standing session, I think, Mark.
This is going to get a little more complicated. We already have a physician. Now we're going to need an attorney as well.
Well, we're everywhere. We have our hands in everything.
Oh, great.
Our business model. So,
That's your business model. Well, Bill, bear with us. We always wrap up every session with sort of a quick recap. Scott, you want to go? You want me to go?
Yeah, well, I'll we just try to do things that we think we've learned, and what I see here is 30 years ago, the PBM industry and the manufacturers started down this path of the rebates for formulary positionings and the construct for the contracts was sort of based on size and control of the plan, and at the time there was a logic to it and it made sense, but as time has passed and each party has acted in its own best interest over time, we have hit the wall. We have reached the point where the system, and I think, Bill's presence here demonstrates this, no longer is serving well the parties that it's meant to serve. And my takeaway here is that this is the beginning of the great unraveling. At least that's what I'll claim until the next time we have Bill back.
There we go. Are you saying the disarming the first ceasefire in the war of all against all?
I think the accumulators and maximizers and alternative funding programs are pirate acts, and that's evidence of a weakened system that, the parties really are no longer benefiting from. And this is just another one now. Now the government, has acted on the lawsuits. The PBMs are starting to settle. They're passing Part D reform. They're passing, Department of Labor proposed rules and so on. So anyway, the great unraveling.
Yeah, I was going to say the deflation, the beginning of the deflation of the gross to net bubble, right? That's Adam Fine's. I'm stealing that from him, um, but that seems to be what we're potentially going to see going forward. Now, as
Yeah.
Bill said, anybody can customize it, and these rules don't apply, right? And we'll see if all of a sudden every plan in 2027 is customized, right? And
Yeah.
but I think we're all sort of a little more optimistic that it'll be maybe not as much as we believe it'll go, but probably not as bad as the worst case. So somewhere in the middle. And I think I totally agree. I think we're finally we started this podcast over what is this? We're in our fourth year
Yeah.
to really move this dialogue forward, and this is the first sort of really big moment where we've seen some concrete actions, and
Yeah.
so I
Yeah.
think that's something that we should all be a little encouraged by.
Yeah. I agree.
And with that, let's wrap up another episode. Thank you, Bill, for joining us. Hopefully, you've enjoyed the experience. And thank you to all of our listeners. We're thrilled that we have, oh gosh, 1,300 downloads a month or every episode. So we're thrilled with that. So thank you. Continue to write into us at comments at prescriptionforbеттeraccess.com and join us. We got an incredible lineup of folks coming in the next couple of months as well. So thank you to all of our listeners.
Resonate.